Prudential Insurance Company, as you know, is one of the top 5 largest group disability insurance companies, and we've handled probably well over 1,000 long-term disability insurance claims against them. But today I want to try to educate potential clients about what should you expect if you've already exhausted your administrative remedies, meaning you filed an appeal. With Prudential, you know, they also offer a voluntary appeal, which means 2 appeals, which you don't have to do. And, you know, the next option is to file a lawsuit. So I want to talk about what is that process like, what are time frames, what are the pros and cons, what are the difficulties, how often do they get resolved, so that someone who's going through this has an expectation as to what they can expect. So
Sure.
Let's start with the first question about filing a lawsuit, and really how much time do you have to file that lawsuit after you've been denied?
Actually, Greg, it's a difficult question. It's kind of a case-by-case situation. It's usually the statute of limitations on these lawsuits is usually about 3 years from the date of proof of loss, which is not really a set date. It can vary. But usually it's 3 years from the date of proof of loss. We like to get them filed as quickly as possible so there's no question that we didn't miss any statute of limitations.
Right, because that's going to be the first line of defense. They're going to say,
Right.
You didn't file your lawsuit timely,
Right.
You're done.
Right.
All right. Once you get your lawsuit filed, what's the average time that these cases take to play out?
Usually after the lawsuit is filed, the defendant has about 21 days to answer the complaint. And then once that answer is filed with the court enters a scheduling order. The order sets out a bunch of deadlines for discovery, which there's not much in an ERISA case, but discovery, mediation deadlines, and then a trial date. So usually it's about a year out, 9 months to a year out for the court to set a trial date.
Okay. And in ERISA, what does that mean, a trial date?
A trial date for an ERISA case simply means that there's no jury trial. This is just a judge reviewing your administrative record and determining whether the insurance company was arbitrary and capricious in the denial of your claim.
All right, let's talk a little bit about this arbitrary and capricious discretionary clauses. What are those, and are those an advantage or disadvantage for a disability claimant?
Well, if the insurance company has discretion in the policy, and it's determined that they have discretion, then the judge will determine the case on the basis of whether they were arbitrary and capricious, which means that they did not have any reasonable basis to deny the claim.
Okay, and what is that? I mean, if the judge first finds that the person was disabled, and then determines that they acted unreasonably, what are the judge's remedies available?
If the judge determines that the insurance company was unreasonable in their decision, then what the judge can do is award back benefits, the back benefits that are owed, and then the claimant goes back on claim for as long as they can continue to be disabled. Or the judge can order the back benefits paid and then remand it back to the insurance company for another review to determine whether the claimant is still disabled.
All right, so it sounds like you have a scenario where you can win the battle and lose the war.
Absolutely.
Per se, because if they do what's called a remand, then it's going back to the company, and and then they get another chance to review it.
Mm-hmm.
What if they review it and still say, no, we're not paying? What are the remedies then?
Well, what usually happens, if they get another bite at the apple, they do the review and they say, hey, we still think that they're not disabled, then they may offer another appeal, which then takes, you have 180 days to appeal that, which is a month process. Then after the appeal, they have another 90 days to review. So you're almost at another year out again with an appeals process, and then you're back to the drawing board, meaning you have to file another lawsuit. It's kind of a vicious cycle.
Does there come a point in time, once you file a lawsuit, does that mean only a judge can make a decision, or is there another way that the claim could be resolved?
Absolutely. Many times, actually, a majority of the time that we file lawsuits, they usually settle for some sort of lump sum settlement where the insurance company will agree to pay a lump sum in order to relinquish the policy.
And what does that mean, a lump sum settlement?
It means that they'll pay you a lump sum of money, which usually can include back benefits and some future benefits. And once that lump sum is paid, it's a settlement. And once that's paid, you no longer have the policy with the insurance company.
And so you're done with them, and
Yeah.
theoretically you could go work another job the next
Correct.
day if you were done with them?
Absolutely.
Okay.
Yeah.
In terms of Prudential, I would say that Prudential is one of the companies that we probably see the most litigated cases against.
Yep, I would agree with that.
And there's a ton of case law against Prudential. You talked about something a minute ago about if they had discretion, and I know that we've argued throughout the country that their policies don't contain discretion.
Right.
And what's the advantage to a claimant if you're able to prove that their policy does not have a valid discretionary clause?
There's actually a very big advantage if you can show that the insurance company doesn't have discretion. Like I said before, when they do have discretion, it's an arbitrary and capricious review, which is a very difficult standard of review to get over. But once it's de novo, that means the judge reviews the cases with a fresh set of eyes, meaning he's basically the insurance company reviewing all of the evidence from the beginning and determining whether the insurance company was wrong for denying the case. And then the claimant at that point has an upper hand.
Okay. So, well, at least more level.
It's a little more level playing field. Yeah.
So I don't want claimants, who are considering filing a lawsuit or involved in a lawsuit to think, wow, there's no way I'm going to win if there's a discretionary clause, because we've won them many times, and there's claimants around the country that have won these cases.
Yeah.
Unfortunately, you're not on a level playing field. The insurance company has the upper hand, but with good lawyering and, a lawyer who knows what he or she's doing and knows the case law and knows the ERISA regulations, you can definitely present a very strong case to the court to show, hey, this insurance company acted unreasonably. But if you have an attorney who doesn't do ERISA, is just moonlighting on an ERISA case because they think they want to try something different, there's no way they're going to know all the ERISA regulations and the hundreds of ERISA cases that have come out that need to be relied upon in order to help prove the case.
Correct.
So if you have a Prudential claim, whether it's an application, an appeal, a lawsuit, potentially a lump sum settlement, no matter what stage you're at, feel free to call any of our lawyers about your claim. We can help you anywhere in the country. One of the things we didn't mention is that because these claims are governed by ERISA, we can file a lawsuit in any court around the country, and we have filed them in as far away as Hawaii, Florida, California, New York. Yep. So we're all over the country filing these cases, and what makes it easy for us to do that is that the courts are paperless now. Right. It's an electronic filing. You almost never have to go to court because the judges don't want to see you, and the claimant never, ever has to go to court. No. There's no required appearance for the claimant. So it's important for you to understand that, because there won't be any inconvenience whatsoever for the claimant with the filing of a lawsuit. So give us a call. Any of our lawyers can help you, and we look forward to the opportunity to work with you.